Now, as you might have observed, relations between Nigeria's opposition parties and this country's judiciary are getting frostier by the day, pushing up hostilities and lowering trust. The opposition parties are increasingly convinced that the judiciary is deliberately leaning on the side of the ruling APC party, a move which they see as biased, unjust, and a clear danger to Nigeria's democracy. In the latest developments, the Labour Party is accusing the Supreme Court of not delivering judgment in Peter Obi's legal challenge to the victory of President Bola Tinubu in the 2023 presidential election. The party said it was yet to receive the certified true copy of the judgment that affirmed President Tinubu as the winner, and that in fact the Supreme Court did not deliver any judgment at all in the Labour Party's case. So how significant is this? What kind of countermeasures are they planning to take? And are those measures pragmatic enough, or is this perhaps more of the same sore loser response from the opposition, as the APC has suggested? Well, for more on this, I'm joined now on the line from Kaduna by one of the Labour Party's most public-facing spokespersons, the chief mouthpiece, in fact, for the Obi Datti Presidential Campaign Council, Dr. Yunusa Tanko. Dr. Tanko, thank you very much indeed for joining us. What on earth is going on with this Peter Obi Supreme Court judgment that we all thought had been signed, sealed, delivered, but now, according to the Labour Party, is undelivered?
Okay, let me quickly clear this particular issue and elucidate and amplify on the matter. Now, on the 25th of October, the Supreme Court wrote us and informed us that there will be judgment passed on our case on the 26th of October. And on the 26th of October, our legal team were at the court. Interestingly, even by the numbering on the files, our case is SC/CV/937/2023, while that of the PDP is SC/CV/935/2023. Even by their numbers, they are quite different cases. But of course, the lead judge, of course, who is Supreme Court Justice John Ian Okoro, on that day made it very clear that they are going to give judgment on the case that Labour Party is to abide by the judgment that will be passed on the by the PDP. Now, unilaterally, he took that particular decision without any consultation with our lawyers, whether we have consolidated on this particular matter or not. And of course, the only area in which there seems to be any form of correlation is on the issue of 25% of vote in Abuja. Number one, our case is very, very clear. One, we took the issue of forfeiture. Secondly, we took the issue of double nomination. Thirdly, we talked about Section 73, subsection 2, which nullified the election where records are not being put according to the provisions of the law. Then finally, there is the issue that we raised about 18,123,000 void volume result that was recorded on the RF, which is a certified true copy of that particular of those particular results of the election. Now, the Supreme Court is in its own thinking just completely ignore these particular issues that we've raised, and then they pass a judgment on us on the PDP judgment alone, without even giving us the certified true copy of the judgment. And according to the Constitution, Section 294, subsection 1 of the Constitution says that you will pass and give judgment. If you pass a judgment, you will give the judgment to the concerned parties 2 weeks after the election. Today, as of now, from 26th of October to the 4th of November 2023, we are almost like 40 days difference. So it is very, very appalling and unacceptable for us to see that those who are supposed to be who adjudicate and enforces the law are the ones seems to be breaking the law. And if that should be the case, if the Supreme Court of the land, who's supposed to be the major area where laws should be kept and be followed accordingly, with due diligence, is flaunting the positions of this own of the position of the Constitution, which is seriously unconstitutional, then I wonder where we will go as a people. This is the situation in which we find ourselves. As we speak, we don't have the certified true copy of that judgment.
Well, I was going to raise the issue of that certified true judgment. How do you read the fact that you haven't got it? I mean, what are you interpreting as the reason why?
Well, I just told you, first of all, when we were giving notice of the judgment, we were giving the notice in writing, and we all complied. And now, remember, at that point in time, there was this particular issue as regard to the forgery case issue of the office holder, President Bola Ahmed Tinubu, which the PDP was pursuing vigorously, and there was attempt in which they want to deal with that particular issue as a reference point. But then, of course, the Supreme Court have a right of giving this judgment in the month of November, which is the time frame that was given. So they were in a haste. They were in a haste to ensure that they passed the so-called choreographed judgment that they want to give to the Nigerian people. So inevitably, everybody was just surprised that the Supreme Court is already ready to give judgment. So the hasteness in it has made them to commit so much of blunders. Because if they have taken their time to give judgment at its when due, maybe probably they will have been ready with the written result and written judgment as it were. But the hasteness has caught them. You see, when you want to commit a lot of false pronouncement, you make a lot of mistakes and leaving clues behind. Now, on this particular matter, it is already an established fact that the Supreme Court has not given us a CTC copy of that judgment 40 days against the constitutional provision of 2 weeks. It is on record. Whether they give it today or tomorrow, they have already committed that particular mistake. And then, of course, I don't know. They are the court, and they can decide on what to do. Already in Nigeria, people have lost a lot of trust in our judiciary system.
Well, some legal analysts, I mean, beyond the issue of the time period, which I believe is 1 week, within which they're supposed to deliver the certified true copy of their judgment to you, some legal analysts have said that the Labour Party is displaying ignorance of the judicial process, because when it delivered the judgment, the Supreme Court said that the Labour Party will abide by the judgment delivered in the PDP case. But your argument is that the facts were not the same and that the court needed to deliver separate judgments. But you didn't raise that in the courts, did you?
Let me explain. You see, those who are arguing in this particular respect need to be sincere to this country. They are not being sincere. Because, number one, when we were at the Presidential Tribunal Court, right from the beginning, the justices made it very clear that the lawyers will sit down and arrange and agree on consolidation of their cases together. And that was agreed. The question you want to put into this particular Supreme Court judgment is that, were there any time in which the lawyers were being asked to arrange and agree on the cases together? I just mentioned the filed cases. They are different, even by number. One is 37, one is 35. There was no time in which our lawyers were asked to consolidate, even in public. What the judge did was just said it unilaterally and say it is binding. This is my position, this is our position. But then we have a right. That is the reason why we have lawyers. The lawyers are supposed to argue on our own part, and that is the position in which the lawyers, but there was no room for any argument on that day anymore. Remember, I said we were notified of this particular judgment on the 25th. Judgment was passed on the 26th. Had it been that there was at least even a 1 day difference, probably aware that we can raise these issues, our lawyers may have already raised this particular issue that, please, You cannot adjudicate on this matter or collapsing them together. Rather, if we must do that, we must both sit down and agree before you make that. So in this case, for those who are already arguing in that respect, are the ones who are ignorant of the position in which mented on us, which we have a constitutional right to challenge this particular position. Probably when we interrogate it in further situation, we still have the right to challenge it.
Well, I was going to ask you, do you see, I mean, I want to come to what you're going to be doing next, but I mean, do you see other competing motives that might be interfering here, that may have prevented the Supreme Court from delivering specific judgment in the Labour Party's appeal? Or are you quite clear what the intentions are here?
Well, allegedly, at this particular fact, they don't have answers to the questions that we raised, i.e., with the issue of forfeiture. They don't have answer on them yet. And secondly, they didn't have answer as regard to Section 73, subsection 2 of the Constitution, which says, of the Electoral Act, which says also that you must record all of these particular facts with regard to the result sheet and all of that, which of course on its own case would have nullified the elections. Then thirdly, they don't have answers as regard to the 18,123 blood result sheets, which was a certified true copy obtained from INEC, which they don't have a report on. And then finally, they did not have answers to the issue of double nomination, which of course some of them will have said that the issue of double nomination has already been dealt with in the lower court, as the case may be. But as we speak now, it is our right to have heard from the Supreme Court to say this is our position. Even if not for anything, we can at least have it on record and take it on for the future references. Then that is the position in which we are taking at the moment now.
So what are your lawyers advising you to do? I mean, what sort of legal reflection are they giving on all this? And I'm wondering what sort of reckoning there should be for this kind of rather embarrassing faux pas. I mean, or is there none at all, bearing in mind, of course, that we're yet to have a response from the Supreme Court? Well, first of all, what the lawyer, in fact, it may amaze you to know, right even on the court, there and then, our lead counsel, Dr. Levy, raised this matter instantly, that there was no judgment passed on our own case. He raised it instantly. So, and then, being a law-abiding citizen as we are, he took the matter up and giving them the laxity of time for the next 2 weeks within the period in which they are supposed to have given us the certified true copy according to the provision of the Constitution, Section 294, subsection 1 that I mentioned earlier on. Now, they flaunted that particular. That was why the lawyers had advised that we raise this matter publicly and let it be known that the Supreme Court, which is supposed to be the highest court of the land, has flaunted its own rules flagrantly against the interest of the people. And we have brought it to the public notice, and the Nigerian people are aware of this particular fact. Even in legal jurisprudence, they are already taking this particular record as against the Supreme Court, as it were. So we will take it up from there, from further decisions and consultation that will be done within the legal framework so that we can be able to take the next step accordingly. But as it is now, the Supreme Court is found wanting as regard to its own rules and regulations, as the provisions of the Constitution enshrine. And I know you touched on this briefly, Dr. Tanko, but do you think that the Nigerian public are becoming less trusting of what the judiciary is doing, what motives are in election-related judgments and the issues surrounding their verdicts that appear to be surfacing ever more these days?
Well, especially when it comes to the level of inconsistency, it seems to us, and the public is already well abreast with this particular fact, they don't believe that even right from the beginning, most of our members felt that we are only wasting our time by going to the court, that the Supreme Court will not even pass any positive judgment, that they are not they are not courageous enough. Let me use the word, that they are not courageous enough, that the system has already been so corrupted to a point that it's the point of no return. Only if there is a kind of a way in which the system will be rejiggled in such a way. Because as we speak today, most of Nigerians don't really see any value as regard to going to the courts anymore, unfortunately. Even though some of us want to believe that the courts are the last hope of the common man. You can see what happened at the last election. The SDP candidate in Kogi State openly said he will not go to the court because it's a waste of time and money. And also, Dino Malaya also ascribed to that particular fact. But you see, we need to push this particular matter into the front burner on a continuous basis. Now, to cap it all, a member, Justice Mohammed Datti, alluded to this particular decay in the system, choreographing the story from the magistrate court up to the part in which it has reached the Supreme Court. So it is no longer the position of the public. It is also a position that is already been established and presented within the judiciary itself. And that, of course, has led us to a very unacceptable position. And we, as Nigerians, cannot, should not, and must not continue to keep quiet as this particular heinous crime against the system, against the people, against the sovereignty of the Federal Republic of Nigeria to continue in this manner. Because most of the institutions that has direct effect on the election have been like as if maybe it's for the highest bidder. Is it on the issue of INEC itself, which we have been calling for the disbandment and disbandment of INEC in such a way that it will carry the election commission, the delineation commission, and the enforcement commission as a way of solution? Or how, in fact, do you actually appoint the chairman of INEC? That has to be looked into, and ardently so.
Let me just come in there briefly.
Constitutional reform, including the electoral reform. But in this case, we're not talking about just a pure electoral reform. No, we're talking about electoral reform and constitutional reform that has a bite, not giving lacuna an opportunity for judiciary to manipulate it and then justify it by legalizing illegality.
Right.
So
I think we've got the point, Dr. Tanko. We're running out of time, so I apologize for interrupting you. But I've just got a text message from the former president. You don't seem to be listening to what I'm saying. Can you hear me, Dr. Tanko? Right, okay. Well, the line appears to have dropped and we're going to have to leave it there. But I've just got a text message from the former president of the Nigerian Bar Association, Dr. Olisa Abakoba, senior advocate of Nigeria. He's saying, I'm not getting the issues here. The Supreme Court has inherent power to apply the old historic rule of abide principle. This is different from the point whether the abide principle applies in the labor case being discussed by your guest. So he mixes the abide principle, which is so clear, from whether in fact it would apply to the labor petition. And that's the that's from the former president of the Labour Party, Olisa Abakoba. Okay, I'm told we've got Yunusa Tanko. Yunusa, very, very briefly, because I'm out of time. We lost you there. I don't think you could hear me. I've just got a text from Olisa Abakoba, who you know, senior advocate of Nigeria, former president of the Nigerian Bar Association, saying that he's not getting the issues here. The Supreme Court has inherent power to apply the old historic rule of abide principle. And this is different from the point of whether the abide principle applies in the labor case being discussed by you. So he says you're mixing the abide principle up, which is so clear, from whether in fact it would apply to the labor petition. So he says that you should please apply to the Supreme Court to clarify whether the abide principle was used in the labor appeal. Your reaction very quickly to that. I gotta go.
Well, that's what I just said. I told you exactly what the lead judge said, that we are to abide by the judgment that were already being given in respect of PDP, where the two cases are completely different. There was no time in which any of our legal team actually sat down and agreed that they are going to consolidate on this particular matter. The Supreme Court only passed that particular position directly to us and said this is the position of the Supreme Court. And of course, if you are going to say that you are going to use the abide principle, at least we should have the right to be informed. We were not informed at all on that particular matter, not at all.
Dr. Tanko, I appreciate your time and for explaining all this to us, and we'll follow this case closely. Dr. Yunusa Tanko is the chief spokesperson for the Obi Datti Presidential Campaign Council. He was talking to me there from Kaduna.